Director of External Affairs for Pennsylvanians for Modern Courts. And we're excited that you're here and thrilled that you were able to join us. We have some folks online, which we're excited wherever you are. This is new for us, hybrid. We're experiencing a lot of different tools and platforms, but if you're in there physically in the library, welcome. It's a beautiful night.
Can everyone hear okay? So unfortunately, our equipment is being weird and it's not connecting through to the sound up here. So if anything from the online speakers, if you miss it, let us know and Carl can either repeat it for you or we can have them repeat it. But I think we are good to go.
Wonderful. Well, I will just do a little bit of an introduction and then I'll turn it over to Carl. So Pennsylvanians for Modern Courts is, we were founded over 35 years ago by Governor Casey, and because of Pennsylvanians, the community was not very supportive or really didn't feel that the judiciary was in a positive place. So Robert Casey created a blue ribbon panel of officials, legals, professionals, and members of the judiciary to come together and increase the confidence within the community around the judiciary. So we've been around for 35 years, and we recently, about 6 years ago, decided that not only were we going to be up in Harrisburg lobbying for merit selection for the judiciary, we decided we were going to begin to educate the Commonwealth. So we created a number of workshops. We created workshops with journalists. We created workshops with judges and journalists, and this is one of them. So we're very excited tonight to talk to you about how to administer an estate. It's a very interesting topic, and we have with us probably the best person that you can have in front of you, because you're going to take full advantage of his knowledge and expertise. And I'd like to introduce you to Carl. Okay. I always mispronounce his last name, and I apologize. Zacharia. Carl
Perfect.
Zacharia. I got
Perfect.
it.
Thanks, Michelle.
Yes. And oh, by the way, if you have any questions and you're online, please put them in the chat and we will communicate to each other that way.
And I'll repeat them as they're asked so everyone here can hear them as well. Well, thank you for having me. Thank you, PMC. Thank you, Michelle. Thank you, Katie. Thank you all for being here for this presentation. Again, my name is Carl Zacharia. Did you want to cover this at all, Michelle, please?
I did that already. That's my intro. So go right ahead.
Gotcha. Okay, I see.
Oh, this slide I would like to just mention, just so everybody knows, you can go to pmconline.org anytime. Also follow us on all social media platforms if you're familiar with any of them. We offer a number of other workshops as well, and this is actually just a calendar of some of the ones that are happening in May and June. Thank you.
I know Judge Ornoni very well. I went to school with Judge Stevens. Good choices. Okay, well, I will again, I'm Carl Zacharia, and I feel like a little homecoming for me because in the 80s, in the early 80s, prior to going to law school, I had a computer store down McKnight Road, kind of like a hobbyist shop, long time ago now. But after that, I went to law school. I'm the founder of Zacharia Brown. We've got an office up here in Wexford, in Brookfield, one in McMurray, in McKeesport, and a couple offices down in Florida. I'm licensed in Florida. I've got an office on the West Coast and the East Coast. And I've been doing estate planning, estate administration, which we're going to talk about tonight, and elder law, which involves long-term care, protecting your assets from being all spent down on nursing homes, that sort of thing. I've been a lawyer for, I can't believe it's been that long. I still feel like I'm new at it. It's been about 30 years now. And I hope you enjoy this presentation. I'm going to do my best. I'm a little informal. Sometimes I talk too fast. So I'm going to try to be cognizant of that tonight. I just caught myself at it. So we're going to talk about what happens when a loved one dies. How do you administer their estates? Let me give you some fundamentals beforehand. when somebody dies, you do not necessarily have to file their will. Stepping back a moment, when you go to a lawyer's office and you have your will done, the lawyer does not then take that signed will and record it somewhere. That does not happen in this state. It happens in Ohio. It doesn't happen in most states that I know of. It doesn't happen in Florida, and it doesn't happen in Pennsylvania. They do not get recorded. It's your last will that matters, the last one that you do. Your last will and testament that matters. And you do not always have to file your will when someone dies. It's not a mandate that when someone dies, file their will. You only file it if you have to probate it, which we're going to talk about probate tonight. For most married couples, if everything is joint, or the spouse is the beneficiary of the IRA, the life insurance, the annuities, you don't have to file that will. You don't have to probate it. Only if something is in somebody's name alone, with no beneficiaries on it, no joint owner, now you have to file the will and probate it. But as with everything in law, there are exceptions. And one of the exceptions is that, and this is pretty important, I think a lot of people do not know this, that if all the deceased person has is a bank account or an investment account with $10,000 or less, there is a law, it's Title 20, Section 3101 of the Pennsylvania Consolidated Statutes, that says if you go to that bank with a death certificate and your next of kin, death certificate and a paid funeral receipt or a funeral bill, if it's not paid yet, they are permitted to give you the money without having to probate the estate, without having to go through the process of probating. And that's what we're going to talk about today, is going to the Register of Wills and probating the estate. Okay, and there's a lot of requirements. Once you file that will in the documents we're going to talk about tonight, there are a lot of requirements that you must fulfill, or you will be notified by the courts that you have not fulfilled your obligations. The document that you will get after you get sworn in as the executor, which is a male, or an executrix, which is a female. Anybody know the plural of executrix? I think it's executrices, but that's too hard to say. A lot of states, even Pennsylvania, we're starting to call that person the personal representative. If there's a will, it's an executor. If there's not a will, which we're going to talk about intestate, what you do when there's no will, that person's called the administrator or the administratrix. And I'm not even going to attempt to say that one plural. But now most states are getting this term, personal representative. But when you do that, you must have the original of the will, and there are some requirements. That will must be, actually, it should be notarized and have two witnesses on it. If you have that, you're good to go. They will file the will. Yes.
What if it's not notarized?
I'm gonna get to that. I'll get to that, yeah. Her question was, what if it's not notarized? Well, if it's not notarized, then you have to have, well, first of all, if I've actually filed wills that were just written in hand by the deceased person and signed, declaring it to be their will. That's good, but all by itself. But I needed to bring in two people who would state under oath and sign a document, an affidavit, that they are familiar with the person's signature, and that is it. That is what their signature looks like. Okay, and if it's not notarized, you have to find the witnesses to the will. If you have a will with two witnesses but not notarized, the witnesses have to sign affidavits. Yes, I was there when that document was signed. That is my signature, and I witnessed that. Okay, if it's notarized with two witnesses, you don't need any of that. All you have to do is take the will in and the death certificate and a few $100s, and you can open up the estate. But if it's not notarized, you have to get the affidavits from the witnesses. And if there's no witnesses, you have to have the two what are called non-subscribing, which means they didn't witness the will, individuals, witnesses. Okay, and so you go to the Register of Wills, who's an elected official, and you begin the process of opening up the estate. What they will give you is called a short certificate. That is a colloquial Pennsylvania term. They're called letters in most other states. Letters testamentary, which means letters, and there's a will, or letters of administration. There is no will, but this person is the administrator of the estate. And we call them short certificates because years ago, before computers, there was these big tablets and they were perforated. And the clerk would write at the top the deceased person's name, the estate number, and who it was given to, and its number. And it would tear off the perforation. So it went from 8.5 by 11 to maybe 8.5 by 7 or something. Have a short piece of paper. That's why they were called short certificates. Okay, I talked about this already. Do I have to probate the estate? Well, maybe not. Yes?
Can we take pictures of the slides?
Can I take pictures of the slides?
Say that again?
Can they take a photograph of the slides?
Absolutely. And they can also receive a copy of the PowerPoint after the program is over. And you can also find the PowerPoint on pmconline.org after the workshop.
Okay, so you could get a copy of the PowerPoint
Yes,
online at pmconline.org?
correct.
Yeah, I'll send a follow-up email with that link as well.
And this is being recorded, so I assume it'll be available online at pmconline.org as well. Okay? So the first question you really need to ask, and these are the questions I ask my clients when they come in, is let's make sure we have to open up a will, open up an estate. Because sometimes you don't have to. If the person died and they owned a house jointly with somebody else, chances are, not always, but chances are that that house will go to that surviving joint owner. Real estate law 101, if it's owned by a husband and wife, what's called tenants by the entirety, just having the phrase husband and wife, means it goes to the survivor. If they're not married, then if it says joint tenants with rights of survivorship, that means it goes to the surviving joint owner with rights of survivorship. But if it has the phrase tenants in common, or it doesn't say anything and they're not married, then that house is owned 1/2 by the survivor and 1/2 by the estate. So you would need to open up the estate to transfer that other half to whomever it would go to under the will. And what is a will? The will is the directions of what I want to do with my stuff after I'm gone. Who gets it? But if they're joint owners and there's an IRA with the beneficiary designation and a joint bank account, no need to open an estate. There's still the obligation to file inheritance taxes, regardless. But there is no obligation to open up an estate to do that. Yes?
Where does it say joint tenants with right to survivorship?
It doesn't. I'm adding that.
How's that designated then?
Oh, where does it say that? I thought you meant where does it say that on the slide?
Well, whatever you have.
The deed. It says on the deed, joint tenants with rights of survivorship. It says from this person or persons to this person or persons, or these persons as joint tenants with rights of survivorship. So it's like at the top of the deed at the very beginning, where they're identifying who the grantees are, the person obtaining title to the property. Okay? If you own real estate in another state, that's a separate probate in that other state. I do a lot of those in Florida. I do a lot of Florida work. People own places up here, they live up here, but they own a place in Florida. It's called ancillary administration, and we do that down in Florida or whatever other state there might be. The processes are pretty similar. So now, do we have to open up an estate? And I talked about this already, but did they own property? Yes. Was it owned jointly? All of it owned jointly? Yes, you don't need to probate. If no, does any property have beneficiaries? If they have beneficiaries, you don't need to. But if it's in that deceased person's name alone, not joint, no beneficiaries, then you don't have to probate the estate. Okay? Do I need a lawyer? A lawyer-like answer would be absolutely yes every time. But that, I've been around for a while. I've been doing this for a long time. It's not a legal requirement, but people find themselves in a world of trouble sometimes when they don't hire a lawyer. So I'm going to give you all the bad stuff here, which is, I'm not trying to drum up business from you. I have plenty I do want to educate you because I had one recently where the lady called me up and she opened up an estate on her own. They sold the house, and then she divvied up all the money with her siblings. And then she got a dunning letter from the state, says, where's your inheritance tax return? And then she got a dunning letter from the Register of Wills, where's your inventory, where's your notice? She didn't know what she was doing. And she found herself in a world of trouble. And the biggest trouble she has was that she already divided up all that money with her siblings. And she hadn't paid the taxes, which is 4.5% in her case, which was about $12,000. She already said she had to go back to her siblings and said, you have to get some of that back to me. She was in a world of trouble with that. If any of them say no, it's her obligation. When you take on that position of being executor, you have obligations. So be aware of that. And there could be, I could just tell you, I might write a book someday about the troubles I've seen. But I'll tell you this one, with your own will, it has always been a common practice in your will to state who pays the expenses of the estate and who pays the taxes of the estate. Common practice had been for many years that the expenses and the taxes are borne by or paid by the residuary. What is the residuary? Well, in a will, you say the residuary is everything else that I have. You might say I leave $5,000 to each of my grandchildren. Everything else gets divided equally amongst my 4 children. That everything else provision is called the residuary. It's everything else. And it says that everything is, the taxes and expenses are paid by the residuary, no matter where it came from. Here's a horror story for you. This happened to somebody. A gentleman passed away. He had a girlfriend for many years. They never got married. He was married before. His wife died. He had 4 children. He had about $300,000 in investment in a house. And he and his girlfriend owned a house in, Gibsonia. It doesn't matter where it was, but it was Gibsonia. And there was a mortgage on that house in Gibsonia. And when he passed away, the girlfriend's brother was a lawyer. And he contacted me and he said, well, I expect fully that the estate is going to pay the inheritance taxes on this house. And I expect that the estate is also going to pay the remaining $80,000 mortgage on this house because of the way that will read. It says the residuary carries all the expenses, all the debts, it said debts too, and the inheritance taxes, all the taxes. Well, I mean, between girlfriend and boyfriend, that tax rate is 15%, the inheritance taxes. Talking about Pennsylvania's inheritance tax, Pennsylvania's death tax. No tax between spouses, 4.5% to your children, your grandchildren, or your parents or grandparents, your lineal ancestors and descendants, 12% to your brothers and sisters, and 15% to everybody else. Girlfriend status is 15%. That was a real problem because of the way the will read. So if you have a will, I would suggest, as I'm doing in pretty much all my wills now, it says whoever inherits, whatever they inherit, they pay their own taxes. They pay their own share. Because you know what? A will doesn't cover as much of the estate as it used to 30 years ago. Why is that? I think a typical person might have a home, let's say a single person here, a home, life insurance, some bank accounts, usually they're joint with one of the kids. Their biggest asset that most people have is an IRA. And who inherits the IRA? The beneficiary of the beneficiary designation. It does not go through your will. When will an IRA be distributed through your will? If there's no beneficiary designation never filled out, or the persons listed as the beneficiaries have died before the person whose will we are probating. Okay, so take a look at your will and don't run to this problem. Now, if you have a family situation that's fairly simple and typical, everything goes to the spouse or children, maybe it won't be so much of a problem. But if you have any outside things going to a boyfriend or girlfriend or a cousin or a friend or whatever, and it might be a different situation. So the lawyer's job is to avoid all these problems. Guess somebody caused one here, but yeah, nobody ever looks at these things, and just be aware of these issues that come up. And if the executor makes a mistake, they're on the hook. They have to fix it at their own expenses, at their expense. So, and I have to put in here too, I'm telling you what the laws are, but the laws, as you know, are very complex. And something they will teach you. Anybody here a lawyer? Well, when you go to law school, there's something that they beat into your head after the 3 years that you're there. That is, there's no right answers. There's never a right answer. It's knowing what all the possible answers may be. It's true. Even the Supreme Court hands down an opinion, 5-4. It's an opinion. And then they flip the answer a few years later. So there's never any direct answer. But I thought your lawyer giving you special advice today. No attorney-client relationship because we're talking. I had to put that one in there. It's often thought of being easy, but it can be dangerous. I'm going to talk to you about some of these dangers so you know. And here they are. When you're probating the estate, I tell my clients immediately, do not pay anybody anything. Just because you've opened the estate and you've got some money from the bank, don't pay anybody. Why? Because there is an order of priority. And if you pay somebody out of turn and there's not enough money for somebody who has a higher priority, you've got to pay for it out of your own pockets. What do I mean by that? Well, I'll tell you a big one is Medicaid claims. Well, let me tell you what the priority is. But the priority is next with the slide. There are claims on Medicaid. If the person was on Medicaid in long-term care, and Medicaid pays for part of their bill, they're a very high level creditor, and you must pay them. And if you don't pay, you have to notify them. You have to notify them. You have to notify them that this person died. You got to get a statement of claim or a release from the Department of Human Services. And if you don't, and you find out it exists, you're on the hook. We talked about the taxes and the expenses. Who pays that? How to properly allocate the assets. I'm going to talk about that. Just be aware that there could be a lot of problems. Not everything's as simple as it seems. Yeah.
I think you want to handle questions as they occur at the end.
Throw them at me if they
Yeah, go back to the last slide. Medicaid claims. Are you using the right term there? I thought that after people turn 65, Medicaid goes away, even if they qualify before 65, and Medicare takes over. So presumably most of your decedents are over 65, so Medicaid doesn't come into.
well, Medicaid comes into play a lot, especially when they're in a nursing home. It's when they're in a nursing home the Medicaid claims come in,
Over 65?
especially over 65. Yeah, that's a lot of what I do.
Carl, what was the question?
Oh, I'm sorry. She's questioning whether Medicaid claims come into play when the person is over the age of 65.
Oh, okay.
Like that they go away, Medicare takes over. Medicare does become their primary insurance of people when they're 65. But it's especially related to long-term, I've been such a home down here, long-term care facilities where Medicaid will pick up a lot of people's bills.
Right.
Just be aware it's there. I'm going to actually go into detail on these a little bit further though. Okay, so those issues to be aware of. It can be a little bit tricky. There's a couple of types of estates here. There's testate, which means last will and testament. Testate, that means there's a will. The person that passed away had a will, and there's an executor named in it, and the will controls who gets what. Now, if the executor name is not around, they passed away, or they simply don't want to do it, then you go to the alternate named executor. If that person is not around or that person doesn't want to do it, the remaining beneficiaries have to choose who's going to be the executor. And that's the way it is when it's intestate, which means without a will. The beneficiaries have to choose who will be the administrator is the title. And that's the term for that. And there's a whole listing of who gets what when you die without a will. It does not go to the state of the Commonwealth of Pennsylvania. They do not get all of your assets. It is a little bit complicated, but I'll give you the first few. If you're married and you have a spouse, of course, and your spouse and you have children together and all the children belong to both of you, your spouse gets the first $30,000 off the top. Everything else gets split 50-50. If you are married and at least one of the children is not yours and your spouse, but from a different marriage, everything's split 50-50, 50% to your spouse, 50% to your children. And if you're not married, it goes to your children And if one of your children predeceases you, it's a phrase called per stirpes. And if you have 4 children, and one of them died before you do, it goes 1/4, 1/4, 1/4, and the 1/4 of the deceased person goes equally to his or her children, the grandchildren of the deceased person. If they have no children at all, no grandchildren, no children, 1/3, 1/3, 1/3. If you have no children, it goes to your brothers and sisters, your siblings, and the same thing if one of them predeceased you, their share goes to their kids. And if you got no brothers and sisters, I had a case like this down in Miami. Michelle's tired of hearing this because I've told this story. I tell this story at every presentation because it was remarkable. This 89-year-old man died. He had no brothers and sisters. He had no children. He was never married. He died without a will. Who inherits? His parents are long gone. He was 89. No brothers, no sisters, no children. Who? Well, that's still not the state. It's never this. The state is, if nobody can find anywhere, then it goes to unclaimed property. But it goes 1/2 to his mother's side of the family and 1/2 to his father's side of the family. And I had to go out and trace a family tree using Ancestry.com, the obituaries, LexisNexis, these sites, different things I use. Accurate is called, to find all these heirs and trace them all down. There was 87 of them. And I had to portion them on their various levels on who gets what. And a lot of these people had no idea who this guy was. But they inherited it anyway, because that's how it goes. So that's how intestacy works. Is try to track it as closely as you can to your blood relatives. Now, if with intestate, again, the heirs have to choose who the administrator or the executor, called the administrator, would be. And the others who are not going to do it sign a simple piece of paper called a renunciation. I renounce my right to be the administrator in favor of Katie Coleman or whoever it might be. Okay? We do those a lot. Here's something else. I don't think I have this in the slide, but just so you know, there's also something called a disclaimer. And a disclaimer is an heir who said, I don't want it. Pass it on to the next person. Do not include me in the inheritance. And I have a case like this right now. It's a $24 million estate. This gentleman had a lot of businesses, lots of buildings, but everything was in his companies. They were just in his name. And he came to see me about his will, and we never did it. But he was pretty young. He wasn't too concerned about it. Then he died suddenly, out of nowhere. Well, the estate is owned 50% by his wife, and 50% by his, $30,000 first, and then 50% to his wife, and then the other 50% to his 4 children, which sounds fine, except that there's a real problem with it. That's $24 million. $12 million of that goes to the children, and there's inheritance taxes owed on that. I have no idea what 49% of $12 million is, but it's a lot of money. And these are all buildings. This is not cash. Nowhere to write a check. So I'm having the children disclaim. They're all disclaiming, and that's going to pass back to their mother, where there is no inheritance taxes. So there are always things that can be done like that. Okay, parts of the estate. So there's the beneficiary designation part. That's your life insurance, your annuities, and your IRAs. There's also TOD accounts, POD accounts, or ITF. You ever see those little acronyms? Transfer on death, payable on death, in trust for, like savings bonds have, ITF. John Smith, ITF, Mary Smith. That means when John Smith dies, Mary Smith inherits those bonds. A lot of bank accounts, I think, are POD. They all mean the same thing. They're beneficiary designations. Just different names. I think investments use POD or TOD. I think bank accounts use POD. Savings bonds use ITF. But they're simply beneficiary designations for investments that are not typically have a beneficiary designation on, like an IRA would, or an annuity would, or life insurance would.
I guess that's the question about PODs and PODs. So they don't go through the probate thing. They drop right down. You have to pay taxes on them, but they drop right down to whoever the beneficiary is.
Yeah. So the question is for the people in the hybrid audience. Those POD, ITF, or TOD accounts go right to the beneficiary. Correct. They do. It's interesting. There is a law. If you email me, I can't remember that, but there is a law that says that when there is a POD account, before the financial institution can give that account to the person inheriting, the POD person, they've got to get a clearance certificate from Harrisburg. So Harrisburg knows they can collect their inheritance tax money. That law is hardly ever followed. It was followed a couple times early on, 10 years ago, but not since. Life insurance is not taxable. No, but these are like POD accounts, which would be investment accounts or bank accounts or bonds, savings bonds. But life insurance is the one thing that's not subject to inheritance tax. There is actually one other. This is not listed on here, but there is, if the deceased person was under the age of 59 and a half and had an IRA, the deceased person, not the inheriting person, the deceased person, the decedent that we call them. If they were under the age of 59 and a half when they died, their IRA is not subject to inheritance taxes. Okay, that's a little known nugget. Okay, probate basics. So who files the will? Well, it's the executor. Sometimes bond is required. You know what bond is? Bond is not part of everyday life. Bond is an insurance policy where the insurance company sells the executor, in this case, the estate, a bond. And a bond is their promise that they will pay. How much the policy costs is based upon the value of the estate. They will pay if the person who's the executor runs off with the money and doesn't pay anybody. The insurance company will pay that claim. They will also then go after that person that ran away with money. Just like a bail bondsman for a criminal case. That's what a bond is. The insurance company will cover it, but it's not like auto insurance where they're going to cover it and you have to pay anything. They go after the person who took the money.
So who determines whether there needs to be a bond?
Who determines whether there needs to be a bond? Register of wills. And they will base that decision based upon the relationship of the person to the deceased person. And most importantly, are they residents of Pennsylvania and within the jurisdiction of Pennsylvania?
Carl, I have one question in the
Yes.
chat. How much time is allowed to pass between when the person dies and when the executor takes action? Is there enough time to find a lawyer at that time?
How much time must pass between the time the person dies and they find a lawyer to open the estate, correct?
Correct.
I don't know that there is necessarily a special time. The inheritance taxes must be paid within 9 months of date of death. And if they're paid after that, there is interest.
That's what drives it.
Who could be the executor? Who could be, let's say nobody wants to be the executor. None of the heirs want to be the executor. This happens a lot, actually. Nobody wants to be the executor. Why? Because there's too much debt. I'm not going to take this on. Why should I do this? There's no money in it. The creditor can actually open up the estate. Actually, any person with an interest in the estate can open an estate. And the creditor can't do that. Now, I've never actually seen that happen. But they can. Under Pennsylvania law, any creditor is authorized to open up an estate. If nobody wants to open up an estate and somebody with an interest wants to, they can step forward and say, I'm going to open up the estate. Maybe it's intestate and everybody's bickering and nobody wants to do anything. One of the heirs can step forward and say, I'll open up the estate. And the other say, well, we're not going to sign a renunciation. We're not going to agree to that. Well, the executor, the person who wants to become the executor, can go to the Register of Wills and file a petition. This is how we do it in law. It's called for a rule to show cause why John Smith should not be appointed the executor. In other words, you got to step forward and say why you don't think that person should be in charge of the estate because they're willing to do it. And so now you tell these others that have been bickering, thinking they're holding some power and some sway over you because they won't sign their renunciation. Now you put it back on them. Say, yeah, well, step forward and tell the judge why you won't do it and why you won't let me do it. And that gets kind of resolved pretty quickly that way. all this stuff happens. So what do they bring with them? They bring the will, as we talked about the will, notarized, hopefully with 2 witnesses. I've had 2 estates that were written on a piece of paper. One was on a piece of paper, one was written on a napkin. And said, "This is my will. I leave everything to these people, and I appoint this person as my executor. I love you all." Signed, dated, an attorney both times. They never did their own will. They do wills all the time. They never did their own. But on their deathbeds, they did them. And that's a valid will. It's called a holographic will, already in, but it's valid. We had to get the 2 people in to say, yeah, that's a signature. I'm familiar with it. We did all that. And we have one right now where we think the handwritten will is a complete fraud. So we're not going to take the case. That's happened too. Okay, again, the answer to the question that you had before is at what point do they have to open up the estate? Well, the sooner the better. But there's not necessarily a timeline on it. I mean, it could happen a year or 2 later. There's going to be interest on the taxes, and there's always problems associated with real estate. Nobody's paying the taxes, nobody's paying the insurance, the maintenance on it, all those sorts of things. Yeah. Oh, well, I can tell you about how much it's going to be. It's usually under $300. Well, okay, so that's a really good question. So the question is, how do you know what the probate fee is going to be? Does it depend upon the amount of your assets? And the answer is, of course, yes and no. But it does depend upon the amount of the assets. But at the beginning, we normally say, I don't know, unknown. And that way, it's always under about $300. Later down, a little bit, I'm going to talk about an inventory. That's got the real value of the assets. And the rest of the money is what you pay towards the inventory that are probate costs. That's when you make it up, when you file the inventory. So you go with the will, take a death certificate, and a couple $100, $300 in cash usually work. The lawyers, like the law firm, is I'll just front the money. I'll tell my clients, give me $500. I will give them a check for the filing fee, and the rest of the money left over will be for the advertising of the estate, which I'll talk about in a few minutes. And that'll cover that as we get this estate open. You're also going to have to get an EIN number. Oh, let's just finish up. I think this is coming up. But where? It's at the Register of Wills. It's downtown in the city county building. You know, the one that's got Dick Caligiuri out front. It's Butler County. It's at the courthouse. Washington County. It's the building next to the courthouse. It's the Register of Wills. In Allegheny County, it's now called the Department of Court Records, but we still call it the Register of Wills. But I think about 20 years ago that changed to Department of Court Records when Allegheny County kind of changed the way they did things. Okay, I think we kind of did all this already. I talked about all this, so I'm going to go right by that one here. This estate information sheet, we don't use that in any county that I am working with anymore. We used to. So I'm going to just kind of go by this sheet because this is not used in Allegheny County, Washington County, Butler County, and Beaver County. It used to be just a special form that you fill out. What we do use is this petition, and this is what you need with the will and the money to open up the estate. It's a 2-page form. It's available here at pacourts.us/forms for the public, so forth. If you went on and Google Pennsylvania petition for probate, you're going to find this form. 2 pages, petition for grant of letters, and it has the deceased person's name, social security number, age, where they were domiciled, where they lived, the county and the address when they died. Over here, they said, what is the value of the estate? In this middle box here to the right, kind of like in the middle of the page there, I put unknown. Unknown on all this. I don't really know. And then the next one is, the first box is petition for grant of letters testamentary, which means there's a will, and then they ask you for the name of the will. Or petition for grant of letters of administration, which means there is no will, and you put in that box at the very bottom the names and addresses and relationship of the intestate heirs. The second page is the signature and address of the executor, and then the costs are written up in the middle on the left side. The attorney's information is on the right side. And then the register will fill out the rest of it. It's a pretty simple form, actually, but you might not know granted letters, testamentary, granted letters of administration. Kind of why we're here today, telling you about these things. And it's not a complicated form. Once you do it once or twice, you'll see it. Okay, so when you go here, you'll get either letters testamentary or letters of administration. Again, called short certificates, as we call them in Pennsylvania. And when you have one of these, it's an official document. It is one page. It says, letters of administration were granted to Jane Smith on the estate of this deceased person, blah, blah, blah. It's like kind of like a ecru or beige colored paper, kind of heavy. Got the seal on, it's all official looking. And those are the letters. And that, you take that and a death certificate and an EIN number, which I'm gonna get to in a minute, to any bank where this person had money, and they will give you access to that money. Normally, you open up an estate account, a checking account for the estate. To open up the estate account, you have to have an EIN number. EIN stands for Employer Identification Number. It is with the IRS, and you can get those online. It is a taxpayer ID number for an estate. This person is deceased. We cannot charge whatever interest is earned on that account, any dividends earned after that person passed away. It's going to be charged somewhere else. It gets charged to the EIN number. And so you will need one of those to open up an estate. You will need one of those to get access to any accounts that have interest where they need to charge it to somebody and they can't charge it to the deceased person. So those three things, the short certificate, death certificate, and the EIN, any bank where this person had money, they'll give you access to it. People find it frustrating when they have to contact Vanguard, Fidelity, some of these other companies to get the stocks that they have, their investments, to get access to them. It takes a few weeks. There's always a lot of forms. They want a medallion guarantee. You ever hear of a medallion guarantee? Anybody? That's a super notary as part of the NASD, National Association of Security Dealers. There's a super notary that guarantees that this is who the person said it was. It's just a lot of jumping through hoops, but we do it every day, I guess. We've been beaten up so badly over the years, we just kind of do it because we're used to it. But a lot of people find it frustrating. Okay, so I give it back to, so with those letters now, or that short certificate, you can do anything that deceased person did. You have full authority. Okay, and it works well for like banks. They like them because they know you have been appointed by the courts. I can't get in any trouble over this. That's what this whole world's really kind of about. So I don't want to get in any trouble by doing the wrong thing. And so if I have court letters, I can do it because it's like that person is standing right here with me. That's why they're there. That's how they work. Okay. So I went through all this. So we get sworn in. Now the person has to provide notice. The executive has to provide notice. It's called a notice of beneficial interest. I'm going to get that form in a minute. It's coming up. Good to advertise the estate. Do you ever see the advertisements in the newspaper? Little square box, those are classified ads. You have to advertise in a paper of general circulation. We normally use the Post Gazette, sometimes the Trib. Outlying counties will use the local papers out there. And the legal journal of the county where the estate was opened, the Allegheny County Legal Journal. Gets advertised in those two places. Why? What are we advertising? Well, we're advertising that this person is deceased. And if he or she owed you any money or you had any unfinished business dealings, you're given notice. That's where the notice to the world in these newspapers. There's a concept called the statute of limitations that we all heard about. The statute of limitations for a contract action, which is a credit card bill. Every time you use a credit card, that's a contract. You're borrowing money from them. The statute of limitations on a contract claim is 4 years. So the bank or the credit card company has 4 years. They have to 4 years before they can sue you to get their money back. Well, this person's deceased, so we can't let things drag out that long. So we do the advertising, and the advertising runs once a week for 3 weeks in these two newspapers. And 1 year from the third time it ran, the statute of limitations is over. They have no claim, you're out. If you haven't filed your claim, you are out. But to file what a claim is, it's a simple piece of paper, one page, called statement of claim, costs like $10, maybe it's 20, I think it's 10 to file it. And it said, we represent Citibank. James Smith owes us $8,888. We are hereby filing our claim. They file their claim. Now they have to be dealt with. And that's what the creditors will do, or should do. After that, you get that EIN number. We get those online. It takes 5, maybe 10 minutes to get an EIN number from the IRS. That quick. Then you have to go through and identify all the assets. I lay them out on the spreadsheet. What assets they had? Who's the beneficiaries? Is it joint? Is it beneficiary designation? Is it part of the residuary? Is it a specific gift? In my real example, I said I leave $5,000 to each of my grandchildren. Those are called specific gifts. The residuary is kind of everything else. So I laid those all out. Then I look, okay, what are our debts? Who do we owe money to? And there is a statutory priority which is coming up, I think, on the next screens. So then we have to file this form called the inventory that I mentioned earlier. The inventory is a listing of the values of all the probate assets. Okay, I want to make sure I might be going too far with this, but I'm going to say it anyway. Let's say somebody died on May 1st. They own AT&T stock, and they had 100 shares at $10 a share. That's worth $1,000. Right. Okay, that's what it was worth on the day they died, $1,000. By the time you close the estate, or you liquidate that fund, it's now $1,100. Because today's stock market, it's $800. But it went up in value. What do you pay the taxes on? The date, exactly right. You pay the taxes on the date of death value, and that is your basis. Basis is for capital gains taxes. Capital gains taxes come into play all the time. Did anybody ever hear my radio show? We do a radio show. It's like every 2 Saturdays a month. Last Saturday I did on KDK, AM 1020, and with Rob Pratt from noon to 1. And a couple of months ago, I thought, I have an idea on how to get people to call in. And so I said, you know, one of the worst things people can do is take their house and put it in their kids' names because they want to avoid inheritance taxes. Let me tell you, it lit up like a Christmas tree, that phone line. Because lots of people do that. But they're not thinking of this other tax. It's called capital gains taxes. If you take your home and you put it into your child's name, a few years later you pass away, your kids may not have to pay inheritance taxes on it because it wasn't in your name when you died. It had been in their name for a few years. I said may not because, as I said earlier, there's nothing concrete. There's actually a law that says an implied life estate, if the parents still lived in that house, it was really still theirs. We want our inheritance taxes, but that's a side story. We'll forget about that for now. So the child then sells the house, said I beat the system, I didn't have to pay inheritance taxes. They're all happy about that. January rolls around and they get a 1099. And they give it to their CPA. What's this? Well, it looks like you sold real estate. Yeah, I sold mom's house. Well, doesn't look like it was mom's house. So I said it was yours. Well, it was in my name, but it was mom's house. Well, according to this, it was your house. You sold it. It was not your home. So it's subject to capital gains taxes. What did mom pay for that house? Oh, $30,000 back in 1970. What did you sell it for today? It's $330,000. Well, it's a lot more complicated than this, but generally speaking, your tax is going to be 20% of the gain. 20% of $300,000 in my example, which is a $60,000 capital gains tax. Now, inheritance taxes would have been 4.5% of the total. I don't know what 4.5% of $330,000 is, but that's maybe $14,000, $15,000. Heck of a lot less than that 60. Why do I tell you all this? It's because when someone dies and you inherit that house and it goes on the inheritance tax return, your basis goes from which is what you acquired for. It wasn't what mom's basis was when she gave it to you. What was her basis was when she gave it to you. You inherit it, your basis gets stepped up to the fair market value of date of death, the amount that you put on that inheritance tax return. That is your die basis. If you sell it for that $330,000, no capital gains taxes, just the inheritance taxes. If you sell it for $400,000, but you list it $330,000, well, you have a $70,000 gain now. But there's always this other tax out there that not enough people know about. So you got to be really careful with taxes. I had one today. I was talking with a family about they want to put down $120,000 as the value of the house. I said, well, the county says it's worth 150. They said, no, it's only worth 120. I said, well, I mean, if you were to sell it, what do you think you sell it for? I said, well, we fix it up, we probably get 200,000. I had to explain that. I might write a book about capital gains taxes on this whole topic. Because I explained you were going to pay a lot more in capital gains taxes with that difference by doing it that way than you would just be taking inheritance taxes. Anybody here have Florida ties at all, or do you ever a snowbird? No inheritance taxes in Florida, FYI. Okay, back to the thing. So we did the inventory, the tax returns. Yes.
Yeah, but if you have a house here, even if you live in Florida, the house here has to go under Pennsylvania probate, so you still have to pay the inheritance tax.
That is correct.
So,
Yeah, her comment was
The question, yeah.
yes. Her question: if you live in Florida but you still own real estate up here in Pennsylvania, when you die, yes, you pay inheritance taxes on this property in Pennsylvania.
Absolutely. Yep.
And anything else you had here in Pennsylvania, like a car or a boat or something.
Before you leave this topic, is there ever any discussion of the Pennsylvania legislation to reduce the level of inheritance taxes? It seems like the perennial thing people talk about, but nothing ever gets done about it. Can you say a word about that?
Has there been any discussion of reducing or changing Pennsylvania's inheritance tax? No.
No.
You don't think anything will happen, and you were like,
Well, when I first started doing this, it was 6% to children and 15% to everybody else. Then around 1998, 1999, maybe 2000, they changed it to the 4.5, 12, 15. But it used to be 6 or 15. That was it. Yeah, who knows? But I don't see them changing it. I haven't heard a word about it. Yeah. It's 0 between spouses and 0 to charities. Yes.
Carl, we have 5 minutes to go, so I don't know if you want to just sort of jump
Right.
through some slides.
Okay. We give the beneficiaries notice that we go on the estate. It's a form called Notice of Beneficial Interest. And then once you've given them notice, you have to certify to the court. Certification of notice of beneficial interest to all these heirs. That has to get filed with the courts. Advertising estate, I talked about that. You got to go through and gather the assets, close the accounts. What I really want to talk to you about here, that's the inventory form. The taxes, there it is right there, the 4.5, 12, and 15%. There's a federal death tax. If your estate's worth more than $12 million this year, you have to pay tax on the value above 12 million. If you're married, it's actually 24 million for both of them. An IRA, you pay inheritance tax and inheritance taxes and income taxes. Both taxes paid on an IRA. And if you're worth more than 12 million, yeah, you pay that federal death tax too. If you have an IRA, it is subject to both income tax and inheritance taxes. No, you pay the income tax. You inherit it, you pay the income tax. Yes. It's still a requirement. You've got 10 years to take it all out and pay all the income taxes on it. Here's a really, really important one. This is what I don't want to miss out. What is the order of priority? When there's not enough money or limited money to pay all the creditors, this is the order they must be paid off in. Administrative expenses. A family exemption is if somebody is living in the household with a deceased person, that's worth $3,500. They can just take that for home expenses after the person died. Administrative expenses are the executive fee, the lawyer fee, the cost of opening the estate. The funeral bill is third. They are next in line. Medicaid and those medical bills within the 6 months prior to dying are the next highest priority. So if we only have enough money to pay these right here, Credit cards get nothing, so don't pay the credit cards, because you have to pay the other bills first. Grave marker, the rent, claims by the Commonwealth, all these, so that's why I tell my clients, don't pay anything. You can't pay anything yet. We are going to determine who gets what. Now, if there's a lot of money, it's not that big a deal. But if there's not, we have to be very, very careful. And I'm constantly notifying credit card companies, I'm sorry, there is no money to pay you anything. Taking their phone calls, they ring every day. I'm calling about the John Smith estate. There is no money to pay this. They can open up the estate themselves, they can challenge it. There's just nothing there. Then when you distribute the estate assets out, be careful that you do it in the right way. They can distribute it according to the terms of the will or intestate, just divided amongst the heirs. Real estate gets transferred according to the terms of the will. If somebody wants to take title to the property, if the executor wants to take the property, sometimes you have to get a court order allowing that. But if nobody's complaining, it's not really necessary, you know. And somebody could take something that's called distribution in kind. In other words, I want that $200,000 house. I'll take that. My brother can have the $200,000 in the bank. And as long as they both agree to it, that's fine. And the executor is the one that signs the deed, called a fiduciary deed, transferring the property to the person acquiring title to it. Not a warranty deed, a fiduciary deed. And then finally, to close the estate up, you have to have something with the heirs. Say, at very least, a receipt. Because I've given you this informal accounting. Here's your money. Here's where the money came in. Here's what went out. Here's your share. Sign this receipt. And then give them the money. Sometimes it might be a little bit, some family issues. The bane of my existence, family fights. There's lots of them in every family. Have them sign a family agreement. I said, here's your accounting. Here's what came in. Here's what went out. I'm distributing it to you. If I miss a creditor, you've got to pay me back. Those sorts of things in there. Or if it's really a mess, then you go to a court with an accounting. It's a process to do an accounting, a formal accounting, where you list everything came in, everything went out, and then you share that with all the creditors and the heirs, and said, if anybody has an issue with this, you got to come to court. Show up in court for my audit, as it's called. And then they have to challenge it. Believe me, those happen. And then the final thing you have to do is file a status report. That's going to be filed within 2 years of date of death. It says, is this case done? Yes or no? Have you given them an informal accounting? Yes or no? Can we close this? Yes or no? But in reality, in Pennsylvania, estates never close. If somebody died 12 years ago, yeah. If somebody died 12 years ago and you found out, oh, they have money in unclaimed property in Tennessee, I need to get another short certificate. You can. The executor can still get a short certificate. I had that when this guy died in 2012. Unclaimed property, $32,000. I just got another short certificate and gathered the rest of the money. I closed that 5 minutes out pretty quick, huh, Michelle?
You did great, Carl. Thank you so much. There actually are no questions in the chat right now. So, I would recommend maybe if anybody in the audience has one or two, that would be great. And we're going to actually stop the recording now.